YouTube channel to provide the public with access to the courts according to the Office of Court Administration's interpretation of the Texas Constitutional Open Courts Clause. Let me, for what little it's worth, just announce that I do not believe that's what the Texas Open Courts Clause requires. But nevertheless, we are trying to comply with all of the mandates and orders out of the Texas Supreme Court and the Office of Court Administration. With those pronouncements being made, for purposes of this plea hearing, what says the state?
Ready, Your Honor.
And defense?
Ready, Your Honor.
The court further understands, well, let me speak directly with Mr. Massengill. Just for the record, are you Travis Glenn Massengill?
Yes, sir.
Mr. Massengill, it's obvious you're not in the courtroom, but it's my understanding you're located in a room here in the courthouse, and that you are participating in this hearing by the same remote video teleconferencing technology that I was talking about. Is that correct?
Yes, Your Honor.
And it's further my understanding that your attorney is also participating through this video teleconferencing technology, but he is in a room separate from the room you're in. Is that correct?
Yes, Your Honor.
And then I just want to advise you that if at any point in time during this hearing, you need the opportunity to consult directly with your attorney outside of the hearing of the court or the state's attorney, you will be given that opportunity. Usually we do that electronically, but since you are located in rooms on the same floor, just either you or your attorney let me know that you need to confer, and we will allow you that opportunity to do it directly. Do you understand that?
Yes, sir.
All right. The case number I have called 10,856 results from an information being filed, and according to the file mark, it was filed today. You have several rights that are related to what I've just stated. Namely, you have the right to require the state to present any criminal charge that they wish to proceed on first to a grand jury before you can be required to stand to that charge or for that charge. Obviously, if it was filed today, a grand jury did not meet today, and therefore the district attorney has not presented this matter to a grand jury. Again, I state you have the absolute right to require the state to present, the district attorney to present his case to the grand jury. Do you understand that?
Yes, sir.
And do you understand that he has not presented this particular charge to a grand jury?
Yes, sir.
Now, I realize there have been other charges that have been brought against you by indictment, but this one alleges, is brought by information. And so I need to discuss with you the rights that you have in that regard. As I've already stated maybe 3 times, 2 at least, you have the right to make him present this to the grand jury. If he presents the case to the grand jury, it is possible that the grand jury might decide not to return an indictment for this charge. For whatever reason, they might not think that there is probable cause to think that this charge should be brought. Or they might disregard what I think is their duty to follow the law and refuse to return an indictment anyway, for any reason against you. But by waiving the right to have or the right to require the state to present an indictment, you're giving up those possibilities that could work to your benefit. Do you understand that?
Yes, sir.
And are you asking me to go ahead and proceed on the basis of the information that was returned, that was filed today in cause number 10,856? Are you asking me to proceed on that information?
Yes, Your Honor.
Now, you have the right to have that information read out loud to you here in open court. Let me first ask you, have you seen the allegations in the state's information they have filed today?
Yes, man. My attorney read it completely.
All right. And do you understand that it charges you, as I read it and understand it, it charges you with a state jail felony offense of theft? Do you understand that?
Yes. Yes, Your Honor.
You also have the right to have someone read this information out loud to you here in our court proceeding, even if you have gone over it with your attorney already. Do you wish to have someone read the information out loud to you?
Your Honor.
And in telling me that, is that because you understand that the indictment charges you with a state jail felony offense of theft?
Yes, sir.
Then understanding the charge, even though you waive the indictment, and even though you waive the reading of the information to the charge of state jail felony theft as alleged in this information in cause number 10,856, how do you wish to plead? Guilty or not guilty? I'm sorry, I didn't hear.
Guilty.
All right, sir. Do you understand that you do not have to enter a plea of guilty? You have the absolute right, in addition to the right that you waive to have the grand jury consider it, you have the right to enter a plea of not guilty, and you have the right to that not be used against you or held against you just because you might have exercised your right. Do you understand that?
Yes, sir.
I have in front of me a document entitled Waiver of Defendant, which appears to have your signature. And I recognize that from a previous document that you have filed in one of the other cases, as well as your attorney's signature. The Waiver of Defendant document says, first of all, that you understand that you have the right to have a minimum of 10 days notice of the charges in the information. And you're giving up that right to have 10 days notice. Obviously, you haven't had 10 days notice. I certainly will follow the law and grant to you some additional time to prepare to make sure you have at least the minimum, if not more than the minimum 10 days to prepare for trial. Do you understand that?
Yes, sir. And I don't need it.
Okay, don't get ahead of us. You also have the right to have a jury hear your case. And that's true even if you enter a plea of guilty, as you just indicated you wish to do. Do you understand that you have the right to a jury trial? That didn't come across well.
Yes, sir.
Okay. When I say it didn't come across well, I mean the video, the streaming didn't deliver the sound very well. All right. So you understand all of that. Did you also understand that the Waiver of Defendant document expressly said you're giving up the right to a jury trial?
Yes, sir.
And is that what you still wish to do?
Yes, sir.
Mr. Keith, your signature is also on the waiver of defendant document. Is that evidencing that you're joining your client in the waiver of these rights that I've talked to him about?
Yes, Your Honor.
And Mr. Smith, likewise, your signature is on the document. Is that evidencing the state's waiver of the right to a jury trial?
Yes, Your Honor.
All right, I'll accept those waivers and we will proceed. Mr. Massengill, there are other rights and admonitions I need to discuss with you. Let's start by discussing, or me telling you, the range of penalties for a state jail felony. The range of penalties for a state jail felony runs from 180 days up to 2 years in a state jail. And it carries the possibility that a fine could be imposed, and if it were imposed, to be in an amount not to exceed $10,000. Do you understand that's the possible range of penalties that exists for a state jail felony such as alleged against you in this information?
Yes, Your Honor.
Now, let me also tell you that I am aware, I think I've already mentioned this, but if I didn't, I am aware that a plea agreement exists in your case. I tell you now that I do not have to follow that plea agreement. I do have to tell you if I'm going to follow it or not, because if I decide not to follow the plea agreement, then the law would give you the opportunity, the right to withdraw your plea of guilty. And if that occurs, we just start all over. And none of this paperwork that you signed or the pleas that you have entered would be used against you when we went forward with your case. An easier way to say what I just said is to say, if I don't follow your plea agreement, you can take back your plea of guilty. Do you understand that?
Yes, sir.
If I do accept your plea agreement, then under Texas law, I would tell you that you would be bound by, once upon a time, I used to say you would be stuck with the terms of the plea agreement, and you could not get out of the terms of the plea agreement if I followed it. Even if you have changed your mind, you can't get out of the plea agreement if I follow it by appealing your case. And that's true, even though the usual rule is that you have the right to appeal. Everybody has the right to appeal, even from a plea bargain agreement case. But I have looked at your plea bargain agreement, and it does have a provision in there that says you give up the right to appeal. And since I've already told you that if I follow the plea agreement, you will be bound by all of the terms, that's one of the terms you would be bound by. And so if I follow the plea agreement that says you're giving up the right to appeal, it means what it says, and you could not appeal at all. Do you understand that?
Yes, Your Honor.
Then let's go forward with your plea. And let me ask you some other questions I'm required by statute and court decision to ask. First, I ask you, are you a citizen of the United States of America?
Yes, Your Honor.
Where were you born?
Midland, Texas.
My next question asks, do you consider yourself presently, which means at this time, to be mentally competent?
Yes, Your Honor.
You know what's going on in these proceedings?
Yes, Your Honor.
Have you been able to understand the charges against you so that you could discuss the facts of your case that relate to the charges and any defenses that you might have, and to discuss all of that and cooperate with your attorney in preparing to defend this matter? Have you been able to do those things?
Yes, Your Honor.
And have you been able to understand what your attorney is telling you about the law and the advice he's given you about what the law means and how it affects your case? Have you been able to do that?
Yes, Your Honor.
Mr. Keith, do you believe your client is mentally competent?
I do, Your Honor.
I accept that representation and advise that based upon my observations and conversations with Mr. Massengill, both today in this electronic or virtual hearing, as well as in prior in-person hearings, I believe Mr. Massengill is mentally competent, and I make that finding. Mr. Massengill, my next question asks, are you you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, Your Honor.
And let me tell you why I asked that question, because I'm not trying to suggest that you wouldn't be or shouldn't be satisfied. Instead, I asked that question just so you would have a chance to tell me if you were not satisfied with your lawyer's work, if you thought it was somehow deficient or legally ineffective. My question gives you the chance to tell me that, and we would then work to correct any deficiencies or legal ineffectiveness if it existed. Do you understand?
Yes, Your Honor.
Now, let me also tell you that since I am giving you the chance to tell me if there's any problems with the attorney's representation, so I could work to try to get those problems, deficiencies, or ineffectiveness taken care of and resolved, that necessarily means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. In other words, now's the time to tell me that if that's your thought. Do you understand that?
Yes, sir.
And understanding that, are you still telling me you're satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir.
Then let's go further, and I need to talk to you. I'm required by law to talk to you and determine if your decision to plead guilty is your decision made of your own free and voluntary will. And so I asked some of these questions to help me make that decision. First, has anybody threatened you, forced you, or tricked you into pleading guilty when you would not otherwise do so?
No, sir.
Has anybody promised you something of value, some benefit, just to get you to plead guilty when you would not otherwise do so?
No, sir.
Are you telling me then that you're pleading guilty to this charge because the truth is you are guilty of this charge, and that's the only reason you would enter a plea of guilty to this charge?
Yes, sir.
All right, so those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
No objection.
All right, Mr. Massengill, let me talk to you about the stipulation of evidence that the state's attorney has offered, and to just mention some other matters that seem to fit right here. First, I tell you that the state's attorney is required to produce some evidence tending to show your guilt, even though you are entering a plea of guilty. That's a part of our law because it helps to ensure that another right that belongs to you is in fact provided to you. That other right is your right, the legal expression is, to confront the witnesses against you. And that merely means you have the right to confront the witnesses against you, and the state has to bring their witnesses into court so that you can see and hear them testify under oath in court in front of you. But this stipulation of evidence says you're giving up that right. Thus, you're telling the state that they don't have to bring their witnesses into court at all. Did you realize you were giving up the right to confront the witnesses against you when you signed the stipulation of evidence?
Yes, Your Honor.
Now, the stipulation also says you're giving up your right to remain silent, as well as your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. But instead, you are giving evidence against yourself. Pardon me, because your attorney's screen. All right, come on in.
I had battery problems, so I've come into this room, but I'll get away from Mr. Massengill. Pardon.
All right,
I apologize.
no problem. I'm glad we're able to do this. Mr. Massengill, I was saying that the stipulation says you're giving up your right to remain silent and your right to be free from self-incrimination. which is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because the stipulation of evidence says on its face, and it operates by law as a judicial confession wherein you are admitting that all of the material allegations set out in the information are true and that you committed the offense alleged in the information, just like it is alleged. Did you realize you were admitting to the commission of this offense when you signed the stipulation of evidence?
Yes, Your Honor.
Then let me talk to you about another paragraph in the stipulation. There's another paragraph that says you are aware that there are court costs in the sum of $290. There are reimbursement fees in the sum of $70, and there is restitution obligations that you would be required to make in the sum of $15,000. Did you realize that paragraph was in the stipulation also?
Yes, Your Honor.
All right, then State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rest, Your Honor.
We rest, Your Honor.
State closes.
Defense closes, Your Honor.
Mr. Massengill, this is cause number 10,856, as I've already announced. The case is styled the State of Texas versus Travis Glenn Massengill. Based upon the plea of guilty that you have entered and based upon the stipulation of evidence that has been admitted into court, I find that you are guilty of the offense of state jail felony theft as alleged in the information. That pronouncement being made, do you know of any legal reason why a sentence should not be pronounced at this time?
No, sir.
Then, following your plea bargain agreement, I hereby sentence you. You know what? I don't think I discussed your plea agreement with you. So let me do that just to make sure that you and I understand it the same way. Pardon me, when I looked at it before, I stuck it under all of the other papers. The plea agreement says to me that you are entering a plea of guilty to the charge in the indictment. I'm sorry, in the information. That plea of guilty will result in a sentence of 2 years to state jail with no fine being assessed, with court costs being assessed in the sum of $290 and reimbursement fees totaling $70, as well as a term of probation being $15,000 for restitution. The plea agreement says, as I've alluded to but not stated, that you would be granted probation for a period of 5 years, provided you follow all the rules of probation. It also says that you will waive your right to appeal, as I have already discussed with you, and that you will participate in what we call the TAP program, which stands for Treatment Alternatives to Incarceration Program. And basically it is an assessment, then based on the assessment, treatment or counseling program for people who have drug or alcohol related problems. And we will determine based upon the assessment whether you have those problems that require treatment or counseling. Now that's all my understanding of the plea bargain agreement. Is that the same as your understanding of the plea bargain agreement?
Yes, Your Honor.
Are you asking me to approve this plea bargain agreement?
Yes, Your Honor.
Mr. Keith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
And,
Yes.
Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
All right, I announce that I will accept and follow the plea agreement in this case. And having gotten a bit out of order, let me get back into order by saying that in this cause number 10,856 for the case style, the state of Texas versus Travis Glenn Massengill, based upon Mr. Massengill's plea of guilty and stipulation of evidence, which was received as evidence in this case, I find that Mr. Massengill is guilty of the offense of state jail felony theft as alleged in the information. And making that pronouncement then, Mr. Massengill, do you know of any legal reason why a sentence should not be imposed at this time?
Your Honor.
Then following your plea bargain agreement, I hereby sentence you to serve 2 years confinement in state jail. I order you to pay a court cost of $290 and reimbursement fees to Scurry County in the sum of $70. I also follow the plea bargain agreement and place you on probation for a period of 5 years, provided you follow all of the rules of probation. Do you understand what the rules of probation are?
Yes, Your Honor.
Did you have a chance to go over those rules with your attorney?
Yes, Your Honor.
Can you follow all of these rules?
Yes, Your Honor.
Will you follow all of these rules?
Yes, Your Honor.
Can you read and write the English language?
Sir.
And I ask that so that, or because if you are able to read and write the English language, as you told me that you can, instead of me rereading them to you, I'm going to cause a copy of the rules to be provided to you so you can read them anytime you wish to read them, and as often as you wish to read them. So since I'm not going to read the rules to you, let me mention some of the rules for emphasis, just because I see these particular rules that I'm going to mention cause the most difficulty to my probationers. We don't want you to have difficulties. We want you to be successful. So let me mention these for emphasis. First, do not break the law, not here or anywhere else. You cannot expect to stay on probation if you're out there breaking the law. Next, stay away from drugs and alcohol in any form. Do not go into places where drugs or alcohol are sold, served, consumed, or possessed. Now that's very, very broad. And so let me narrow it some with 3 exceptions. You may go into a grocery store, even though they sell alcohol. You just can't purchase, consume, or possess the alcohol. You may go into a convenience store. That's where people often buy fuel for their vehicles. You can go there, for instance, to buy fuel or other items, even though a convenience store, unfortunately, also sells alcohol in most convenience stores. You can do that, but you can't possess, purchase, or consume the alcohol while you're there or anywhere else while on probation. And finally, an exception is you may go into a restaurant, even though they sell alcohol there. And I say that as an exception because not every restaurant tells you if they sell alcohol or not. Not everyone sells alcohol. If they don't tell you, how would you know not to go in there? And so I make that exception just so it doesn't appear that we're trying to trick you into violating your probation. So you can go into a restaurant without worry about whether it sells alcohol, but you cannot possess it, purchase it, or consume it. And you cannot be with other people who are doing that. You will report to probation before the 5th month of each day. I'm sorry, the 5th day of each month. and you'll do that each and every month. You'll do so here in Scurry County and at, Mr. Keith's dead battery device went totally dark. I'm told that you reside at 11,461 East Highway 180, Hermley, Texas. Is that correct?
Yes, Your Honor.
You will continue to live at that address and not move to another address unless and until you get permission in writing from your probation officers. But I would also tell you that permission is easily obtained. They're not trying to keep you from moving. They just want to know where you are, where you're going to be, and to make sure that's not a place that gets you in trouble. Your financial obligation includes an obligation to pay restitution totaling $15,000, along with the court cost and the reimbursement fees. That totals $15,360. And I'm told that you're asking permission to pay that restitution obligation at the rate of $260 per month. Is that your request?
Yes, Your Honor.
Do you also understand that there is an additional $60 per month obligation to pay probation service fees?
Yes, Your Honor.
Those two together total $320 each and every month. Do you have the ability, with funds you have and earnings that you are making, to make those payments each and every month, totaling $320, and still be able to take care of yourself and your dependents' needs?
Yes, Your Honor.
All right, I will accept that request and will make and approve it, and making it a part of your rules of probation. While on curfew, you'll observe, while on probation, you will observe a curfew, and you will not leave your home county for more than 3 days without written permission. You will perform 160 hours of community service restitution, and then you will come back to see me on the 15th day of April, 2021, for a probation performance review. It's a time when I check to see how you're doing on probation. We want you to succeed on probation. If the report at that time shows that you're following all of your rules, we will say, good for you, that's what you're supposed to do. If you are not following all of your rules, but we think we can still assist you in making your probation, we will redirect you, even imposing some additional sanctions. But our whole purpose is to try to get you successfully through your probation without going to the penitentiary. I have 2 sessions of reviews on April 15. One of them is at 9:30 in the morning. The other is at 1:30 in the afternoon. I will give you your choice. Which session do you wish to come to?
The afternoon, sir. You seem to be in a better mood in the afternoon.
All right, sir. I don't think you've seen me that often in the afternoon. You sure wouldn't have said that after yesterday if you had been around yesterday afternoon, but that's beside the point. 1:30 in the afternoon is fine. That's when your session will be. That's where when you will come. Because of COVID, we may space our people out that come for reviews in the afternoon. Your probation officer, if that occurs, will give you specific information about what specific time to come in the afternoon. I think I told you, but if I didn't, you have 160 hours of community service restitution that you'll have to do doing community service. Your probation officers will give you ideas of where you can do that and get credit for it. Now, these are not all of the rules of probation. And since they're not all of the rules, or since I didn't mention all of the rules, even though you have read the rules, let me give you a chance to ask any question you might have about any of the rules. Do you have any questions?
No, Your Honor.
Then those will be your rules, and those are the orders of the court. Mr. Oliver, do you want to see, when do you want to see Mr. Massengill? Or when do you
Judge,
want to see him?
because of tomorrow's calendar, I will see him on the 12th, which is Tuesday at 11 o'clock.
All right.
Do you have a deputy there to take his thumbprint?
Yes, I do.
Okay.
It's on your ass.
All right, Mr. Massengill, your first report to the probation office is on January 12th at 11 a.m. You will need to report there to satisfy your obligations and start, well, your probation starts now. I will ask the deputy who is here bailiffing for the court to come into the room where you are with the judgment, and he will obtain your fingerprint. I'm sorry, he will obtain your thumbprint on the judgment. Once that is accomplished, you will be excused for today, and your probation officer will see you Tuesday, the 12th of January, 2021 at 11 a.m. Do you have any questions?
Yes, sir.
Thank you, sir.
Thank you.
After the thumbprint, you may be excused.
Yes, sir.
We're in recess.
Judge,
Yes.
Shelley's here. She has a question for you before you get off.
Okay.
Skylar Holman, I believe is his name. Y'all put on bond supervision.
Ms. Duggan, hold on just a moment, would you? Oh, no. Go ahead. Hold on. Hold on.
If what? I guarantee you he didn't tell him
I
that.
know, but I want to, I want to know.
Because he was never in the room with the guy
No, but
to tell him
yeah.
individually anything.
He just said personally.
Oops, he can still hear it.
How are you, sir? Good.
Okay. Sorry. Mr. Massengill, the deputy will be there in just a moment.
He's here.
Okay.
527, 1973.
Okay. Thank you, Ms. Duggan.
Can you hear me?
Yes, ma'am. Is this a
The young man,
harassment?
Skylar Holman, that y'all placed on bond supervision, he is under the impression, or he informed me, that you advised him he did not have to report this month for bond supervision.
Nope, that's not what I told him.
I know, but I wanted to make sure.
What I told him was he did not have to pay his supervision fee and reimbursement fee today.
Okay,
He would have to pay it at his first appointment.
okay. I just wanted to make sure I was on the same page with you. I knew I was, but I just wanted to double check.
Good. I appreciate it.
Thank
I
you.
appreciate you being on the same page and also for checking just to make sure. We're all,
Thank you.
Thanks, Judge.
see y'all later.
They eventually locate the other person. The person that was hidden from them, I guess, or had from them.
Mr. Wesley.
Was it Wesley or Davis?
Oh, they got Bridget Davis up here.